Welcome, everyone. Good to have you here. I just love this intro music. It's kind of something fun to play with. Hi, this is Rick Durfee from Durfee Law Group and Probate Law Group, and I'm here with co-host and co-counsel
Michael Coberline. Nice to see everybody today.
Yay! Good to have you here. We are going to have a lot of fun today talking about the 5 things every professional needs to know about probate. And this is a fun topic. We want to welcome and encourage questions. We try to keep track of that and watch the chat line here. So if you do have questions, chat those into us, and we will do our best to answer them as we go along. Some of you may know this, but before I was a lawyer, I had another career. I actually was teaching religious studies at a university. I have a master's degree in religious studies. And I enjoy looking at old human stories. And one of the oldest stories of humanity, in fact, is disputes over dead people's property. And in fact, just to refer to the Bible, as soon as the Garden of Eden is a thing of the past and death is introduced into the world, the very first story that's told is 2 brothers that get into a fight over property, and one kills the other one in order to acquire their property. And that story of the dueling brothers actually becomes an archetypal story that's repeated over and over again in media and movies and books. And here's the deal. If you want to steal something from somebody, it really helps a lot if they're dead. And dead people have no natural defenses. They don't fight back. They don't have any means of protecting their stuff. So if you want to rip them off and take their property, that helps if they're dead. And our legal system is designed to minimize that or prevent that, or at least give the politicians, the tax collectors, and the lawyers first go at it so they can grab the stuff before everybody else rips them off. But we're going to go through that whole process of what happens when a person dies, what happens with their stuff, what happens with their real estate, and we're going to talk about the 5 things. And so, thing 1, not to be confused with a famous book that identifies thing 1 and thing 2. We're going to have 5 things. So thing 1 is, go ahead, Michael. What's thing 1?
Thing 1, why should a real estate and other professional care about probate?
Yeah, so the whole idea of probate and what happens when a person dies touches everything. And it touches everything for a whole bunch of reasons. One is, it is unavoidable that when a person dies, their property is going to change hands. It's going to go from one owner to another. But it's also deeply ingrained in our culture, in our legal system. We have a phrase people hear and refer to all the time, the law of the land. That phrase was actually first used in a document called the Magna Carta, where a document which, by the way, had little effect in terms of its legal application, but became a precedent that was later employed. And it said there are certain things that are rights that we just have, and they go with the land. If you live on the land, if you farm the land, if you possess the land, you possess these rights and they can't be taken away from you. That's the root of the inalienable rights that were memorialized in the Declaration of Independence and later in the Constitution. There's also that law of the land includes the rule of law, which is the idea that the right to govern is limited and that the sovereign, the politicians or the king or the president or the prime minister, whoever, the police, the sovereign, the governing authority also is required to follow the law. And you might think these are kind of big esoteric things, but they're very real. They have an impact on everyday life and will kind of be an underlying theme that goes through everything we're going to talk about today. One thing I want to say is, as a professional, you're out there, you have clients, they look to you for advice, and you can't give good advice if you don't know what the rules are. So understanding how property transitions when a person dies is vital. Another reason why understanding probate, part of this thing one is when a person dies and property is changing hands, there's bargains and opportunities. There's good deals out there to be had. And if you can connect with those good deals as the professional advisor, not only can you get business for yourself, but you can help your clients and develop clients. And I think it's important for professionals to recognize that, particularly with our key clients, where we're the prime advisor that the client interfaces with, we want to be the concierge whenever they have an issue of any kind, an accounting issue, a tax issue, a real estate issue, a banking issue, an insurance issue. We want them to come to us so that we can then tap into our professional network of advisors that we work with and say, yeah, I don't do that, but I know someone who does. Let me connect you to that. And I think especially people in the real estate profession, that's a crucial thing. If you're not the concierge that people just think of, oh, when I need something, let me call and get a referral from you, they're gonna call and get that referral from somebody else. So you want to be that person. So you've got to have the professional alliances. You've got to know enough about these issues that you can spot the issue, that you can talk intelligently to the client about it, and that's how you're going to have people come to you. And a question people often ask, especially when they're working with lawyers, well, okay, if I send my clients to you, am I going to get referrals from you? So I'm going to tackle that head on right up front here. How do you get referrals from a law firm? How do you be the one, of the many participants we have online here with us in this seminar? How do you get to be the one that the lawyer calls and says, hey, I need a real estate professional in this deal right here? And I'm going to give you some secrets. First of all, and you know this, if you have a referral source, someone who refers you business, you're always going to be loyal to that referral source. You're never going to take a client from one referral source and hand it over to another referral source. And so lawyers are in that same boat. If you refer somebody in, the lawyer's going to be loyal to you, and that's going to come back to you. Or at least if they don't do that, they're not going to be in business very long. So what has to happen is you have to develop new business together. And we can talk about how that can work in the probate process. But you develop new business together. You go from this existing client, and then how do we network from that existing client to other existing clients? You go from this professional relationship. How do we go to others? But then what happens for an attorney in particular when we go, oh, I just had a client say, I want to list this property for sale. Who should I call? I'm going to just confess what really happens in the mind of a lawyer. First of all, often we try to avoid the deer in headlights look like. I have no idea. So we think about, well, who do I know that's a real estate professional that I can work with, that I have confidence in, that I can send my client to? And the truth of the matter is, the names that come to mind are often the names of the people that we've had a conversation with recently. And so that changes. I can tell you, in 3.5 decades of doing this, I've given many, many, many referrals to real estate professionals, and it's almost never been the same one, because usually the referral goes to, well, who was that called me last week? Oh yeah, I talked to so-and-so last week. Well, they're a good person. Let me send you over to there. So having frequent contact with and reasons to be engaged with other professionals, whether it's a CPA or a financial planner or a banker or whoever you're dealing with, that's going to be crucial to developing those referral relationships. And I guess the last part of thing one that I want to mention is, my co-counsel is going to say, do you need to do this yourself?
Oh yeah, absolutely. So if you don't have your own estate planning done, that's one way that you can really get a testimony, for lack of a better word, of how important it is. And when you do talk about these kinds of things with other individuals, you can tell them, yeah, I've got my estate planning done, I've got my plan in place, and I don't need to worry about probate. And you should do this too. This is something that could be beneficial for you for these reasons, uh, which we're going to be talking about during this presentation.
So, Mike, I hear a lot of people think and ask this question. Well, probate's a tax, right? So, is probate a tax? And why don't you tell us what the answer to that question and what the heck is a probate?
Sure. Yeah. So probate, as you probably know, is not a tax. Uh, Probate is a process that individuals who have passed away, their estate has to go through in order to transfer to their beneficiaries. If they don't have other planning mechanisms in place, then probate is a state requirement. Essentially, you're transferring legal title of assets from the decedent to living beneficiaries.
Awesome. So, let me build on that. Probate is, in its simplest terms, a form of litigation. You're going to court. You're invoking the power of the court, the power of the state to intervene in private business and property ownership affairs to determine who's in charge, who's entitled to this property, and how do we handle creditor claims and debts and other liabilities and the cost of administration to determine who gets this stuff. And because it is in court, it's public, so it reduces privacy, it's adversarial. All the parties in the process get a notice. And I'm sure many of you online here, if you've experienced this or seen this or have family members, you get a notice, and in simple terms, the notice says, hey, do you want to fight? If you want to fight, you better fight now, or you lose your right to fight forever. And now, I've had this conversation so many times, it's almost funny to me. People will bring this notice to a lawyer, and they'll go, no, I don't want to fight. I'm not that kind of a person. But I don't want to give up any of my important rights. So will you represent my important rights in this probate process? And the lawyer, of course, says, I would be happy to do so for a fee. Write me a check. I will be your advocate to protect your rights. Now, if you get more than one lawyer protecting the rights of more than one client, what do you have? It may not always rise to the level of quote unquote a fight, but it's going to be a process that it's going to take time. It's going to cost money, and it's going to have to be worked out. So in the probate process, there are very strict rules that have to be complied with in the courts, and we're going to look at a lot of those. And if you don't comply with those rules, you can mess it up big time. You can create big problems, which brings a question: when can I do this myself, and when do I need a lawyer? And candidly, there are forms, especially in Arizona, especially in Maricopa County. Some of the outlying counties don't do this as well, but Maricopa County has awesome forms online. There's a great deal of it a person can do themselves, and particularly in a simple, uncontested, no big deal probate, that might be a good idea to do it yourself. I will acknowledge, or should point out, however, a lot of the probate cases that we have come to us involve people that have started it themselves, and they get to a point where it's so complicated and so easy to mess it up that they're just concerned that, wow, if I do one thing wrong, it's going to create issues. So I need legal help. We actually have a couple of cases right now where the probate was actually started by the individual themselves, and then they said, I'm done. I can't go any further. I gotta have help. So sometimes, even if a person continues doing the probate themselves, sometimes just having a lawyer they can call on and let me buy some time here to get some counsel and guidance on how to walk through this probate process. So Mike, here's the big question that's going to kind of segue into thing 3. Thing 1 is understanding probate affects you professionally and affects your clients and is a mechanism you can use to gain clients. Thing 2 is understanding what the heck is a probate, and now when is a probate necessary?
So this is a simple answer. Probate is necessary when property is owned by a dead person.
So wait, if a dead guy owns something, we have to go to probate.
That's the answer.
Okay. So how often do dead people own things? Every time. In fact, somebody asked me, how do I completely avoid taxes? And the answer is simple. Don't own anything and don't make any money. But no, I want to own stuff and I want to make money. Well, okay, then you're going to pay taxes. How do I have no taxes when I die? Well, die broke. How do I avoid probate when I'm dead? Well, that's one way. In fact, option, this is thing 3, by the way. How do we avoid probate? And we're going to tie this back to why should you care as a professional advisor. One way, in fact, the easiest way is to simply own nothing, have nothing when you die, then you won't own probate. But in general, the general rule for avoiding probate, and this ties to so many things that real estate and other professionals have to deal with. You avoid probate when you cause your assets to be subject to a contract that dictates what's going to happen if and when you die. And we're going to talk about several ways that's done, specifically as it relates to real estate. But an example of this, and I think a lot of you, everybody here, in fact, if you don't have a bank account, I don't know how you can afford to be on this webinar with us. Everybody has bank accounts. You go to a bank, you set up an account, and they'll ask you every single time, do you want to name a beneficiary? In fact, sometimes they'll say, you must name a beneficiary. The better banks will require you to do so. Why do they do that? Banks do that for a couple of reasons. The biggest one is they don't want to get sued when somebody dies. But they want to have a beneficiary designated on the bank account so that when the owner of the account dies, there's no question about who the account goes to. And in Arizona, and frankly, in most states, there's some places where this is a little squirrely, but in Arizona for sure, and most other states, if there's a beneficiary designation on a financial account, on your checking account, your savings account, or your retirement accounts, that beneficiary designation trumps everything else. It trumps your will, it trumps your trust, that controls, and that's who it goes to. And some of the times when that gets challenged, I've seen that challenged in situations where there's an unmarried couple or where the clients were commingling funds with the business, but that's really tough and really rare. That beneficiary designation just trumps everything. So Mike, here's my next question that I want your help on, because a lot of people think this. Well, I have a will. I went and prepared a will. Maybe I got it online. Maybe I even paid a lawyer for it. I have a will. Isn't that going to avoid probate? I'm not going to have probate because I have a will, right?
Yeah, unfortunately, that's not the truth. So if you have a will, then you're going to probate. And there's a few different places where you have probate. You have the testate estate, where that just means that you have prepared a will and that you're going to be submitting that to the court and then go through the probate process to transfer the assets to your beneficiaries. And then there's the intestate estate, which means that you died without a will, but you still go through the probate process. So having a will doesn't mean that you're not going to go through the probate process. It might make it a little more simple for your heirs who are involved in the probate.
Perfect. So a will, you're still going to go to probate. A will just gives the court instructions on what you want to have happen, and it's an expression of your intent. So a word that gets thrown around a lot in this discussion of probate is the word estate. Estate. In fact, it's the second word in real estate. What is estate? What does that mean? Estate means property on the one hand, but in this context, there's some technical meanings, and it's often used, it's ambiguous and it's used interchangeably, but the technical differences have a huge impact on taxation, on liability, on whether we're in court or not in court. So estate can mean assets that are subject to probate. So there's usually a qualifier, the probate estate. An estate, the word estate can refer to assets that are subject to taxation when a person dies. That would be the taxable estate. And an estate can refer to assets that are not taxed and that are not subject to probate, the non-probate estate. So that word estate, what's included in the estate? Well, what do you mean by that? Do you mean what's subject to probate? Do you mean what's subject to tax? Do you mean what transfers outside of probate? So that word estate is a tricky word. It's a word to be cautious of. It gets abused, and its ambiguity causes confusion. So we want to sort through this. And I guess another question I'm going to throw out to Mike here is, Mike, what's the difference between probate and an estate tax?
So the estate tax is now a little over, the exemption is a little over $22 million
For a married couple.
for a married couple. Yeah, a little over 11 million for individuals. So if you have an estate that is valued at that amount, a little over a million or a little over 22 million, if you're married, then you're going to pay an estate tax on the amount above that, the exemption. With the probate, it's not a tax, it's a process, and so it's a completely different thing. Is that what your question?
Yeah. So the tax and the probate, they're different things. That's the main thing. And there's exclusions to both, and the estate tax exclusion and the probate exclusion are not the same. We're going to talk about the probate exclusion in a minute. And let's point out, Arizona does not have an estate tax. It used to, but it no longer does. There are still 8 or 9, I can't remember the count exactly, states that do have an estate tax. And some are very aggressive. Some, the threshold is very low, just $1 million. And if you have more than that, they're going to tax it. Or Oregon is one, as an example, that if you own property in that state, or if you're domiciled in one of those states, you can end up having an estate tax. And an estate tax is, I want to point out, is not a tax on receiving the property. If you're the receiver of the property, that's technically an inheritance tax. An estate tax is on the transfer of the property. So it's the person giving the property, the transferor, not the transferee or the receiver of the property. So receiving property by inheritance does not result in an estate tax. It may, and there's like 2 states that have an inheritance tax, not very many. But Arizona has neither an estate tax nor an inheritance tax. There's some other kind of critical tax issues that relate to an estate and to property, and specifically to real estate, that are pretty significant, that happen when a person dies. And one of those is what's called the step up in cost basis. And this is a question or an issue that crosses marital property rights, real estate property rights, taxation, and probate issues. So it's kind of a multidisciplinary question. And let me explain this in simple terms. I think most of you probably get this, but sometimes hearing it refreshes our memory. When we buy a piece of property, the price we pay for it, that's our cost basis. By the way, that includes any debt that we incur to pay the purchase price. So if we pay $100 for a property, that's our cost basis. If that property then goes up in value, and if you've been around as long as I have, you've seen periods of time when properties go up in value, where properties stay flat, and sometimes even where they go down in value, which is really an uncomfortable experience. But when property goes up in value, when they appreciate in value, that value above the cost basis, that appreciated value, that is called gain. And when you sell a property, that gain is subject to tax. And because property is treated as capital, property is not income, your real estate is not income, it's capital, it's a capital asset. That gain on the appreciation of a capital asset is called capital gain, and it's taxable. Now, to my knowledge, this is the only advantage of death. Other than, I guess, we're relieved from the care and suffering of this veil of wrath and tears, as the poet says. but beyond obtaining our otherworldly rewards, there's only one benefit that I'm aware of to death, and that is that the property you own at the time of death gets a step up in cost basis. So if you bought it for 100, it appreciates in value to 150, and then you die. That property, as it is inherited, the cost basis goes up to the value as of the date of death. Now, interestingly enough, and this is going to come up in a few minutes here when we talk about some other stuff, in a community property state, for a married couple, that step up in basis happens to 100% of their assets. So if a married couple owns that property, they bought it for 100, it goes up to 150, and one spouse dies, the cost basis steps up to 150. In non-community property states, and this is something you should know, if you don't know this, you're going to step on something and it'll either stink or hurt. In non-community property states, the spouses each only own half the property. So that 100 property purchased for 100 that went up to 150, when one spouse dies, there's a step up in basis on half. So the half of the living spouse doesn't step up in cost basis. So there's an advantage to owning real estate that appreciates in value and owning it in a community property state and obtaining that community property benefit. And that's something, by the way, other devices, certain deeds and certain trusts can preserve that. If there are tenants in common, and you, a real estate professional, you got to know this, a tenant in common owns typically an undivided percentage of interest in the property. If there's 3 owners, you all own an undivided 1/3 interest, unless it specifies. It can specify you own 46% or 22% or some other number, but if it's unspecified, tenants in common own an undivided equal interest in the property. If one of those tenants in common dies, the dead one gets a step up in basis for their undivided interest, but the other people don't. So this is going to come up when we talk about some deeds here in a second. I want to touch on some other tax issues. And again, I'm going to pester Mike here. I'm going to ask him a question. Mike, does an estate, when somebody dies, does the estate have to file a tax return?
Yes.
Would you like to elaborate? So if they're going to file a tax return, do they need an EIN?
Yeah. So when a person passes away, if they have a trust, or if they, if they don't, they have to get an EIN. They have to file a tax return, and they have to make sure that. And when I say the person, we're going to be talking about this a little bit later, but it's in Arizona, we call it a personal representative, who has that fiduciary duty to make sure that the estate is wound up properly. And part of that is to make sure that all the costs and things and debts are paid, and also that the taxes are taken care of. So that's.
Yeah, cool. And by the way, the process to get an EIN is something anybody can do, but is typically something that most people don't know how to do. And so you're either going to get a lawyer or a CPA in most instances to help you get that EIN. That's something that a lawyer or a CPA can typically help you with. And I want to mention that the taxation of the estate has an impact on subsequent conveyances. So when we do deeds later on, there may or may not be a tax depending on how that estate is set up and how the EIN is structured. So we'll go into that in more detail.
I wanted to mention one thing too. When you are setting up an EIN, if you are going to help clients with that, or if you ever need to give someone just some help with that, there's a lot of companies out there that charge to get an EIN, and you can get one on the IRS website for free. So there's a lot of individuals who take advantage of people's not knowing about that. That EINs don't cost. So
yeah, in fact, let me say something on that too, because with probate estates, if you haven't gone through this personally, or if you haven't helped a client through this, anytime somebody dies and we go through this probate process, there are hucksters that come out of the uh, uh, forest and try to take advantage of them. They send very official looking documents that look like government records that say, you have to file this and you have to pay us, whatever, $89 or $152. There's always a price on it. And a great many of those are completely bogus. You do not have to file them. They're just hustling you for business. And they tried to make the form look like some official government notice to increase the probability that a vulnerable person who doesn't know better and who's not well advised doesn't tell them, nah, that's bogus. You don't need to file that. So you, as the professional advisor helping your clients, need to be able to recognize those. Now, I want to transition. We're still talking about thing number 3, which is how to avoid probate. And we're going to talk for a few minutes here about deeds. And deeds are something that I have been surprised how often real estate and other professional advisors know just enough about deeds to be dangerous, but not enough to do things right. So we're going to address some of these issues and some of the things that come up, and hopefully add some clarity and at least give you some resources. And there's 3 deeds or 3 types of deeds. Well, actually, there's several here that we're going to talk about. But I want to, first of all, explain and walk through the difference between a warranty deed and a special warranty deed and a quit claim deed. And you've all seen these. And they're very significant because the use of these deeds affects your subsequent ability or the cost of obtaining title insurance or breaking the chain of title for title insurance purposes. And we see an overuse in particular of the quit claim deed. So a warranty deed, and when you buy real estate and there's title insurance, you're going to get a warranty deed. And that warranty deed warrants that the transfer of title is valid and effective against everybody else out there in the universe. You get absolute title, and that's the simple title. It's your title. A special warranty deed also has a warrant, but it doesn't warrant against everything in the universe. It only warrants against that conveyor or that grantor. It says, if I'm deeding property to you as a special warranty deed, I am warranting that I have no other claims on this property, and I warrant that I'm giving you the property. So how much warrant does a quit claim deed have? And the answer is 0. There's no warrant whatsoever. So just saying, when do we use a quit claim deed? You use a quit claim deed when your claim to the property is tenuous, subject to challenge, maybe completely bogus, and you're just giving up whatever you have, whatever you might have, and that might be nothing. So when conveying property from you to a trust, to a family member, to a business entity, please don't use quit claim deeds. They create problems down the road. Please, that's a situation where you don't have title insurance, so you don't want to use a warranty deed, but you do want to use a special warranty deed because it keeps that chain of title intact. You use a quit claim deed where, well, I've been camping on this property uninterrupted for the last 17 years, and I have a claim to a title by right of adverse possession. So I'm going to quit claim my tenuous claim by adverse possession to whoever. That's a time when a quit claim deed is appropriate. But most of the time, quit claim deeds are just not appropriate, and using one in a situation where it's not appropriate makes the person who prepared the deed look silly. And we don't want to look silly. So we're going to talk now through some other related deeds, and we've mentioned tenants in common. It's pretty typical. So here's the question. If you own real estate in your personal name as a tenant in common, and you die, is probate going to be necessary? And the answer is
Yes.
yes, because a dead guy now owns that property, a dead person. So tenants in common, they have a place. There's times and circumstances where they're highly appropriate, but it's almost never, I should say, and there's probably some exceptions, but almost never appropriate to have a person in their individual capacity who is subject to, and unavoidably subject to, for that matter, death, to own that property as a tenant in common. Because what's the probability of death? 100%. So if a person who has a 100% probability of death owns that property, what's the probability then of probate? 100%. So we want to not have it owned. So which brings up a very common deed device, and that's a deed with rights of survivorship. And currently there's two varieties of this in Arizona, and there used to be only one, and we're going to talk about the difference. So Michael, there's joint tenants with rights of survivorship and community property with rights of survivorship. What does that mean? What's the difference?
And so I just had this come up recently from a friend of mine who's a financial advisor. And she asked me, she called and said, hey, what's a better way to do this? And is there a difference between joint tenancy with rights of survivorship and community property with rights of survivorship? So as you know, joint tenancy is with rights of survivorship is when you have individuals who own a property together, and if one of them passes away, then the full property automatically transfers to the survivor. That is treated pretty much the same for married couples if you have joint tenancy with rights of survivorship or you have community property with rights of survivorship. So if you're going to list the whether it's joint tenancy or community property with rights of survivorship, it doesn't become much of an issue if they're a married couple. Because they are going to be taxed the same. As Rick was saying earlier, you're still going to get a full step up in basis, whether it's listed as a joint tenancy with rights of survivorship or community property with rights of survivorship. The issue becomes with the issue is with the IRS if they aren't completely familiar, if the person who's working on that particular transaction isn't always familiar with every community property state, it might trigger in their minds, if you have joint tenancy with rights of survivorship, it might trigger in their minds some challenges, but they're supposed to be treated the same. So what I told my friend who's a financial advisor is, if you want it to go as smoothly as possible, then list it as community property with rights of survivorship. That way you tip off the IRS that this is community property, and it gets a full step up in basis because it's community property with rights of survivorship. There is a distinction if it's a joint tenancy and they are individuals who own the property as opposed to a married couple. If it's two individuals who own the property, then the step up in basis is treated similarly to those non-community property states where half of the value of the asset is allowed a step up in basis for tax purposes.
So thank you. This relates back to that step up in basis thing. And I kind of want to build on what Mike said and add, if a married couple owns property in Arizona and they acquired that property during the term of their marriage, it is by definition community property, period. They have to do something to make it not be community property. So even if they take title as joint tenants with rights of survivorship, it's still community property. The challenge is the IRS doesn't know that. So some years ago, Arizona added this community property with rights of survivorship just to remove that ambiguity, make it perfectly obvious. Yes, this is with rights of survivorship, and yes, it's community property. So that community property with rights of survivorship designation on a deed is only available to married couples And by the way, the marriage has to be legally recognized in the state of Arizona. That's been an issue in the past. It's less of an issue now, but that's an important factor. So let's talk about another kind of deed that's relatively new, that's only been around for a few years. Some of us that have been around a while remember when we didn't have such a thing, and that's a beneficiary deed. And this is a cool deed, and it's a probate avoidance device. A beneficiary deed allows you to do with real estate the same thing that people do with financial accounts. You designate a beneficiary, and the beneficiary owns nothing while you're alive. They only obtain an interest when you're dead. And you can change that beneficiary, so you can take them off or put somebody else on, or change them, or you can sell the property and extinguish their interest. So their interest is not perfected or doesn't vest until you die. So a parent who wants to give their property to their child automatically when they die, the remedy used to be, well, you have to do joint tenancy. So mom says, well, I want my daughter to get my property when I die with no probate. What can I do? And I don't want to pay for a trust. Okay, she'd put her property in joint tenancy with her daughter. Well, that created problems. And I'm going to tell you a specific, this was a real situation that happened to me a long time ago, but mom puts her property in joint tenancy with her daughter. Her daughter was in the middle of a nasty divorce. The daughter ended up with a whole bunch of liabilities and decided to file bankruptcy. The daughter had to list all of her assets, including her joint tenancy interest in mom's property. The daughter didn't live in mom's property, so it was not subject to the exemptions from bankruptcy that residents get. And it was a Chapter 7 liquidation. So the bankruptcy trustee was able to, quote unquote, liquidate the daughter's interest in that joint tenancy property with mom. And the bottom line is, at the end of the day, after a bunch of wrangling and lots of legal expenses, mom lost the house because of the daughter's debts. So joint tenancy with another person is a dangerous thing to do. Don't do that. If you want to leave the property to them, that's why we had these beneficiary deeds. Okay, mom can name daughter as the beneficiary, and the daughter has no interest in the property. She would not have to list it in the filing of a bankruptcy. She would not have to list it in a marital dissolution. It's not hers. She doesn't get it till mom dies. So mom lists this beneficiary on a deed, and that transfer is not effective till mom dies. It's a very powerful tool, and it's very appropriate to use that tool, particularly for smaller estates where the only asset is a piece of real estate, and there are no creditor issues or substance abuse issues of the next generation. And we must point out, and as professionals that work in this industry, you need to know when somebody dies and there's a beneficiary deed or a joint tenancy, any kind of a deed with the rights of survivorship, you have to record a death certificate. And that's something that title companies are going to require from your clients. You might as well figure it out right now. One other kind of deed I want to hit on here is a deed of easement. And I know real estate professionals, you are all experts on this. You understand all about easements. Easement is a diluted form of title. It's a limited right of possession. So it typically means a classic example is an easement for a road. Well, I don't own the title. I can't put up a fence around it. I can't graze my cattle on it, but I have the right to drive my vehicles over that easement for a road, for access to a landlocked property, for example, or something. But there's another kind of easement. Michael, we were talking about this earlier, an environmental easement. Why don't you tell us that story? Because that was a cool story.
Yeah, sure. So I was at my house and my kids were watching a movie, and I don't, some of the movies I like that they choose and some I don't. This was one in particular that I thought maybe I wouldn't, but as is wont to happen from time to time, I was sucked into it a little bit. And it was this movie about this guy who was super rich and pretty spoiled, and he was forced to go to his aunt's farm to learn how to work. And during the time he was there, he learned that his aunt was going to lose the farm. And towards the end of the movie, he starts to develop a heart, and he decides that he wants to help his aunt to keep the farm. So he offers her a bunch of money, and she won't take it because she's not, she has the pride that comes with owning land, I guess. And so he remembers in one of the classes that he took something about land trusts. And during his time on this farm, he and one of his, I think it was one of his nephews, they watched these wild horses running along in in the property. And so he remembered from his class that, oh, if you have wild horses on the property, that's one thing that uh, can allow for a land trust to be established. And so it kind of goes along to where he goes to the bank and he gets it set up, and the aunt's able to keep the farm. But I'm going to let Rick talk about the technicalities behind that, because that was pretty much the first time I had heard about that particular vehicle.
So what happens in a situation like this is the property owner would grant an easement. And that easement can be granted to a governmental agency like the BLM, or it can be granted to a charity, Nature Conservancy, or there's a whole bunch of other land trust type of charitable organizations. And in that particular scenario for the movie, the easement would be, we're going to grant an easement for wild horses to run free on this property. Now, if there's an easement like that over the property, what does that mean? It means several really significant things. It means, for one, that the property is no longer complete. It's no longer whole. It's now fractionalized. And so the mom who owned this farm didn't own the whole farm. She owned the farm subject to the easement. So the value of the property went down for several purposes. It went down for property tax purposes, so mom could afford the property taxes. It went down for estate tax purposes. So somebody when mom dies and the property transfers to the next generation, and the IRS says, well, is it worth more than the $11.4 million? Well, it used to be, but not now, because there's an easement on the property to allow wild horses. So think of it as a practical matter. If there's an easement for wild horses to run free on the property, what can we not do? Well, we can't put up fences that would prevent the wild horses from running around. We can't subdivide the property. We can't build condos and swimming pools. So now that property has to be used for agricultural purposes only, and we have to let the wild horses in. We can't keep them out. So now the big city can grow all around that little farm, and it's going to stay a farm, and the nature of the property is going to be conserved forever. So that's a clever device that can be used. By the way, the mom in that situation, if she granted that easement to a charitable land trust, would have received a present income tax deduction for her charitable gift. Again, would have reduced the value of her estate for estate tax purposes, and would preserve the nature of that farm forever as a farm. That's something that can be very valuable when we want to keep a high value heirloom asset in the family for multiple generations, and minimize the amount of taxes they're going to have to pay. So we're going to leave deeds now, and we're going to, I have a chat question here. Is that a question? What if the couple are married to husband? What if the couple married and the husband already owned a house? Is the house automatically community property? Oh, great question. So this is back to our deed question. So when a couple marries, if a spouse owns property prior to marriage, that property begins as separate property of the spouse that owned it. So what is separate property and what is community property? Which is a great question, by the way. Property that you have before marriage is separate. Property that you receive by inheritance or gift is separate. But property that you acquire during the term of the marriage, unless it's separate, is community. So husband and wife, or married couple, let me just say that. Married couple goes and buys a piece of real estate, regardless of how they take title, it's community property. But they can say, oh, by marital agreement, it's going to be the separate property of the spouse or that spouse. But absent some kind of explicit written designation of the properties belonging to just one of them, it's going to be community property.
And one very real addition to that is you'll have people who get married, and one will own a house before they get married, but they'll still have a mortgage on that house. And if they still have a mortgage on the house, which is likely the case, then the equity that they build together during their marriage is part of the
Unless they have a prenup.
community. Yeah, unless they
So,
have, right.
so this is a reason for a prenup. So one of the spouses owns a piece of real estate, and they want to preserve the separate property of that real estate coming into the marriage, even though they're going to be paying down the mortgage. So a very typical thing we would see in a prenup is we would say, we're going to use community funds to pay the mortgage, but we're going to treat that payment as if it is rent to this separate property spouse that owns the property. So there's no community property interest in the pay down on the mortgage or in the appreciation of the property. That's a reason why in today's world, if you're coming into a second marriage or a later in life marriage and you own assets or you have children, if you don't do a prenup, you're just crazy stupid. And I can say I've been married 38 years, only one spouse, only one wife, and I believe in the sanctity and the long-term nature of marriage. But even with that, if it's a late in life or a second or a third marriage, and you have assets or you have kids, you just got to do it. So I want to talk for a second about title companies and how this relates to probate and some of these deed issues. It's important to know that title companies, their function is they're going to insure title. They're going to say, yeah, this title is clean, and we're going to ensure that when it's conveyed, the grantor can warrant that conveyance against the claims of all others. So because the title company is in this chain of risk, they have some power over the transaction. And one of the powers they have is they can say, well, we won't insure title unless you do A, B, C, and D. And I've had the experience, I can say, well, A, B, C, and D are not required by law. They're not necessary. And the title company can say, we don't care. Comply with them or pound sand, we won't insure title. So you got to do what the title company wants you to do in those kind of situations. But having said that, sometimes using a title company is not necessary. And in particular, these situations when the conveyance is between related parties or between closely held entities. So transferring a title from your name individually to your trust, you don't need a title. You don't need to insure title, as long as you use a special warranty deed and not a quitclaim deed. Transferring title from you individually to your LLC. Do you need a title company? No, as long as you don't mess it up by doing a quitclaim deed, do a special warranty deed. So knowing when you need and don't need a title company. Now, I'm selling my property to an unrelated third party. Should I use a title company? Well, the buyer will want to have a title company because the buyer wants to have their title insured. And the seller will want a title company because the seller will want to not have a lawsuit when some defect in the title arises later. So in a sale to an unrelated third party, that's when a title company is critical. And by the way, we're talking about probate. Why are we talking about title companies and probate? Because often it's the title company that ends up saying, yeah, we can't insure title on this property until you go to probate. And they're going to say that because there was a hiatus in the title because somebody used a quitclaim deed or because a dead spouse didn't sign a prior deed, or there's some defect in the title arising often from a dead person. And the only way to fix it is to go to court and get a probate to dictate who's going to get it. So we have a few more things under thing 3 here to avoid probate. And we want to talk for a little bit here about trusts. So Mike, does a trust avoid probate?
So if you have a trust, then the potential is there to be able to avoid probate. The question is, did you properly fund the trust? And if you properly funded the trust, then yes, you can avoid probate. If you did not properly fund the trust, then no, you will likely not avoid probate. And what does it mean to properly fund the trust? Simply to name your assets in the name of the trust.
So with real estate, that means we have an actual deed going to the trust. And what kind of a deed do we want? Not a quitclaim deed, please, a special warranty deed. And for whatever reason, we have purveyors of trusts, people who sell trust, hucksters, who will tell people, they'll tell your clients are being told this. Oh, if you have a trust, you have no probate. And then they'll say, well, do I need to deed my house to the trust? And they say, oh, don't worry about that because you have a pour over will. It'll go to the trust automatically when you die. Well, how automatic is that? Well, remember, if you have a will and you own the property in your name personally, do you have to go to probate? Yes. So having the trust, but failing to transfer the title to the trust triggers probate. By the way, for people who have a trust, who were smart in the first instance and deeded their house to the probate, what's the number one reason why we end up in probate anyway? I'm going to tell you, this is an interesting thing. This happens so often, it's really tragic almost. People, they set up a trust, they deed their house to the trust, and they go, great, I've avoided probate. And then time passes and interest rates change and they go, wow, mortgage rates are at the lowest they've ever been. I'm going to save a whole bunch of money if I refinance my house and get a new mortgage at the new lower rate. So they refinance their house. Now, just saying, 30 years ago, we could not find a lender on the planet that would ever loan money to a property owned by a trust. They always required the property to come out of the trust before they put the mortgage on. These days, about 50-50, about half the time, the lenders will, in fact, loan money on the property if it's owned by the trust. But there are still a great many lenders that will say, you know what? No, we're not going to spend any time or energy reviewing that trust to see if it's okay. We're only going to do the mortgage, give you a loan if you take the property out of the trust. So the house owner takes the property out of the trust, deeds it out, gets the new mortgage, intending to deed it back to the trust, and then procrastinates it, doesn't do it, puts it off. And then somebody dies. And then they go to sell the property. The children go to sell the property and go, hey, mom and dad had a trust. How come we have a probate? Well, because mom and dad took the house out of the trust in order to refinance it, and now we have a probate. So that's something for you to be aware of if you're working with your clients and you're helping them refinance a house. By the way, another little interesting thing on refinancing, you should know that on a residential property in Arizona, a purchase money loan is a limited recourse loan. What does that mean? It means the lender's recourse is limited to recovering the property on a residential property in Arizona. That only applies to a purchase money loan. If it's not a purchase money loan, so if it's a refinance or a second mortgage that was not obtained at the time of purchase, it's not a purchase money loan. Technically, the lender's recourse is not limited to recovery of the real estate. They could pursue a deficiency judgment. Now, in Arizona, how often does that deficiency judgment happen? I will tell you, I have never once seen a lender go after a deficiency judgment on a residential property, but they could. And that's enough reason to pause and make sure that on those non-purchase money refinance deals that there's enough equity that you're not going to end up having a deficiency if there's a foreclosure. Some things to be aware of when deeding property to a trust. In Arizona, you have to designate or you have to disclose who the beneficiaries of the trust are. That gives some people some heartburn, but it's no big deal. If it was in their personal name, it would be disclosed. Another issue that comes up is, well, I'm deeding my property to the trust and mom and dad are the trust. What happens when mom and dad die? Now there's a new trustee. When there's a change in trustee and property is owned by a trust, typically there's some paperwork, an affidavit or a certificate of trust, or it depends on the situation. Sometimes the title company will accept a simple letter. That may or may not need to be recorded, and candidly, that comes down to the requirements of the title company. I've seen title companies say, we have to record the affidavit identifying the new trustees, and other title companies will say, show us the affidavit. Okay, we're good, let's go. So that's an issue to be aware of. We want to cover for a minute here another probate avoidance device and another way of holding title, and that is to use a business entity to hold title. And I kind of want to walk through the chain here so you get this, because a lot of people, even professionals, fail to understand this. And I want you to think about this metaphor. The tail follows the dog. So if the dog is in the yard, the tail is in the yard. So think about that metaphor now. So we're going to have a piece of real estate owned by a business entity. So the real estate is in the entity, it's owned by the entity. And then the entity is owned by something. If the entity is owned by a trust, if the entity is in the trust, the tail follows the dog, the underlying real estate owned by the entity is in the trust. And so is there a probate? No. But if the real estate is owned by the entity and the entity is not owned by the trust, is the real estate in the trust? No. So people think, oh, my property's in my LLC. And then we have to ask, well, who owns your LLC? Oh, I do. Oh, it's not in your trust? No, no. So then the LLC is potentially subject to probate. So these business entities, whether it's an LLC or a limited partnership, the entity itself needs to be owned in a manner that prevents it from being subject to probate. Otherwise, we still end up with a probate. And especially with properties that have been around a while, you might encounter real estate owned by a corporation. And there's some tricky tax things with corporations. Corporations can be taxed as a C Corp, where it's a tax-paying entity, or as an S Corp, where it's a flow-through entity. And particularly properties back in the 60s and the 70s even, a lot of properties ended up in S Corps. There are draconian tax consequences, or can be at least, when that property is sold and the money comes out of the corporation. With a C Corp, it can be subject to double taxation. The corporation pays the tax on the gain when the property is sold, and then when the funds are distributed from the corporation, they're subject to another tax. With an S Corp, there's internal cost basis and external cost basis, and they can result in some serious taxes. So if you encounter real estate owned by a corporation, that is an instance where you don't necessarily need to know the tax issues. You just need to know there are tax issues and get that person in touch with somebody who knows how to navigate that. Because sometimes there are things we can do to get the property out of the entity at a minimum tax cost, or to at least minimize the taxes when they take them out. The key principle here is, remember, the tail follows the dog. So great, I'm going to have all my rental properties owned by LLCs. Okay, cool. Well, then your LLCs need to be owned by your trust. Wait, I don't have a trust. Well, then you don't have an estate plan, and you think you're being clever, but all of those properties are still being subject to probate. So we're ready now to talk about thing 4. So thing 1 was all this stuff about probate and the transfer of property on death affects you as a professional advisor. Thing 2 is understanding what probate is. It's a form of litigation. Thing 3 is there are many ways to avoid probate, principally by having the property subject to a contract of some sort that causes it to transfer without having to go to court. And that can be a deed, that can be a trust, it can be a business entity. Now, thing 4 is, okay, we did our best to avoid it, and it didn't work. We're going to have a probate. And by the way, how many estates in Arizona go to probate when there's property? Probably nobody knows this, so I'm just going to tell you. The numbers are more than half. It's surprisingly few people, even people that have trusts, few people actually are successful at avoiding probate. There's a lot of them out there. So what's the threshold? And Michael, tell us what the threshold is. There's a different threshold for personal property and one for real estate. When are we small enough we don't have a probate, and when are we big enough we have to have a probate?
Sure. So with personal property, if you have property that is in excess of $75,000 minus liens and encumbrances, then that is something that will trigger probate. Real property, same thing, except it's $100,000. If the value exceeds $100,000 minus liens and encumbrances, then that also triggers probate.
So when estates are below the probate threshold, and by the way, the personal property, that includes cash in the bank, there's an abbreviated process that we don't call probate. It's actually a form of probate. We don't call it that. What is that? Tell us about that.
Yeah, so it's a small estate affidavit that essentially you list your property and you can submit it to the court, and then they sign off on it. And it's a lot more simple, lot less time intensive and expensive. But again, it's only for those estates that are small estates, which are under 75 in personal property or under 100,000 in real estate or real property.
So I want to mention a couple of things. With personal property, that does not have to be filed with the court. Real estate, it does have to be filed with the court, and the court actually issues an order that gets recorded that operates as a transfer of the property. One of the reasons why it's important to have beneficiaries designated on financial accounts, I've had people come in and they say, Mom had a bank account, it's got $700 in it. The bank won't give it to us. Can we do a small estate affidavit? And I'll say, yes, you can. Here's the form, you can do it yourself. And they go, I'm not willing to do that myself. Will you help me? I say, yes, but by the time you pay a lawyer for it, you're going to spend more than $700. And they go, so I spend more money than I'm going to receive to get the money. Yeah, or you do it yourself. So I've actually seen people walk away from the bank account because it's not worth it to them to pay the lawyer, nor is it worth it to them to fill out the paperwork themselves, and they'll just walk away and abandon the $700 bank account. So having a beneficiary designated on that bank account avoids that completely. Now the probate process, and we're gonna talk about this in some detail with our remaining time here. In fact, I'm going to share a screen with you if I can figure out how to do this so that you can see this really cool probate process diagram that we have. I hope you can see that. If you can see it, somebody nod their head so I can see. Okay, good. You can see this. So you can see this. This is an informal probate process. There's 3 stages, and there's a whole bunch of issues with probate that we're going to talk about as we go through this. But Mike's going to give us kind of an overview of how this works and why it's significant. And this kind of relates back to that issue that we addressed earlier, that there's a lot of rules. They have to be technically complied with. And if you screw them up, you can create more expense and more problems and lose some of the benefits that are going on in probate. So Mike's going to talk us through now these 3 stages of an informal probate.
So the reason that we put this together is because, as you can see, there's a lot of steps to the informal probate process, and it's very systematic. You do this, and then you do that, and then you do the next thing. And so in putting it on a diagram, we were able to make it a little more, it's just helpful to be able to see the whole process all together, and then to take it step by step. And so as you can see, each stage represents kind of where we're at in the probate process. The first stage is how you get to the point where you submit all of the documents to the court. So as you can see, I'm not going to read through each one of these, but each one of these steps is essential in being able to either submit your will to probate and also apply to be a personal representative. Or if there isn't a will involved, then the individual still needs to apply to be personal representative. I should mention this, that a lot of people think that the personal representative that is named in the will is automatically going to be the personal representative that is actually administering the estate. That is not always the case. It's often the case, but they still have to apply and be appointed by the court to be personal representative.
So Mike, you're using this word personal representative. Explain what that means. Why that word? What's that versus an executor?
And so that initial stage is essentially to show the court you do or do not have a will, and then to have a personal representative appointed. that personal representative is going to be the person who has the power to administer the estate. Essentially, they're going to be able to act or stand in the shoes of the decedent and be able to transfer their property, pay their debts, pay their taxes, all those things. So they're acting as a liaison essentially between the decedent and the court to make sure that those assets are transferred, hopefully based on the intentions of the decedent. Um, so that's essentially stage one. Stage one is that getting to the point where you have a personal representative appointed. Then the next stage, stage two, you're notifying everybody, all the interested parties, which are typically the heirs, people who are going to receive under the will, or if there's no will according to the intestate statutes, which the intestate statutes essentially are listing those who are going to receive property in the event that there's not a will. And so you have to give notice to those individuals, proof of notice to the court. And then this is also the stage where you will get the creditors involved and make sure that if there are any known creditors, that you send them a notice indicating that there's been a personal representative appointed, and that the person that has either borrowed money from them or has a credit card with them or whatever kind of debts that they have has passed away, and that they're settling their affairs. In that situation, the creditors have 4 months to respond, and then I believe it's 60 days that we as representatives, personal representatives, or the attorneys involved have to respond to their to the creditor's claim. Then from there, you kind of enter into the negotiation stages, and that would be either with the creditors and or with family members who may or may not be disgruntled. If you have family members that are in agreement with everything and you want to get things situated in one document, you can do a family settlement agreement. And this is where attorneys are good to have on board, because if you have some family members who are having a difficult time understanding why they're not getting everything that they want, you can have some people on your team to help you to kind of walk them through why it's important to come to an agreement instead of going to litigation. Most of us know that if you go into litigation, that it's just going to be more costly. In fact, I know a couple who they had land in Long Island, and their family fought over this property for 2 years, and they didn't have any idea how much it was worth. They just knew that everybody wanted it, and they had over $200,000 in litigation fees with attorneys, and when it came down to it and they all figured out how much the land was worth, I think the land was worth less than what they had actually paid in attorney's fees. So, whether litigation is worth it to an individual is a personal decision, but we always try and get people not to litigate, because not only does it usually cost more money, but it also poisons families. And that's the last thing that we want to do in this process. And then stage three, essentially you can close out the estate and not have to do a lot of these if people are willing to waive the accounting. If they're not willing to waive the accounting, then you have to go through several more steps, and it typically takes another 6 months to go through that process. So we always try and encourage people. We always want to do the best thing for the estate, but usually that means waiving the accounting and closing the estate.
So critical questions that come up, especially for real estate professionals, is, well, when can I sell the property? when in this process, these three-stage property, when can the real estate owned by the person who passed away be sold?
Oh, are you asking me that
Yeah, I'm
question?
asking you that question. Go for it, Mike.
Ask it again.
So
Please.
when can the property be sold? Okay, grandma passed away. We want to sell grandma's house. Do we have to wait till the end of the year of a probate procedure to sell it, or how soon can we sell the house?
Yeah, well, so as soon as the personal representative is appointed by the court, they get some letters of appointment, and they should also have, that individual should also have, if they haven't already, gotten a death certificate. And as long as they have those two things, then they should be able to go and start the process of getting the real estate sold.
So in Arizona, when you actually start, when you file papers with the court, how long does it take typically to get that order of personal representative?
Order of personal representative, usually it doesn't take very long. I did one recently that it took a couple of weeks, but I think that's because they were having some administrative issues, and also because of COVID-19. I'm sure that has made it more difficult for them to go through that process. But typically the registrar has it done within 1 to 2 days after you file.
Right. It used to be, for those of us that have been around for a while, you could stand at the filing desk of the probate registrar and they would give them to you on the spot. Now because they screwed up so many times and caused so many problems, now they have it go through a couple of rounds of review, and it takes a day or two. But I want to add, outside of Arizona, we have a probate right now that's actually in Canada, in Alberta, and the probate was finally the letters, the equivalent of the letters. It's not the same thing up there. Were finally issued here in May, and we started the process. I think it was in September of last year. So what, 8 months? And so that whole time we couldn't sell the property. We were just twiddling our thumbs. So in Arizona, typically, to be able to sell the property, once we file, it's typically going to be a couple of days, and then you can sell it. So now we sell the property, the personal representative has the money. When should they make distributions and give stuff to the heirs? What's the best time? When in your three-stage process?
So as when they have all the debts paid and after they've paid the taxes, is a time where you can make the distribution. However, I would say that one caveat is that the personal representative doesn't always know everything that's in the estate. Sometimes we know everything, but sometimes there's an additional debt that may crop up 6 months later, or something else that requires money from the estate. And so an issue that can be avoided is if you have a debt that comes up that you didn't know about that's in the estate, it's important to reserve some amount, keep some amount back for at least, I would say, 6 months to a year. And so you can make an initial distribution after taxes and debts are paid that you know of. And then after that, keep a reserve, and once a year has passed or so, you can distribute the rest.
Yeah. So let me kind of say that same thing, but build on it a little bit. So after stage one, once the personal representative is appointed, you really should not make big distributions, but you can make some little ones. Keep the lights on and keep somebody from living on the street. But then you really have to deal with the creditors and the bills and the taxes before you make any big distributions. And even after you make the big distributions, we typically recommend to our personal representatives that they keep a little war chest, keep some amount of money. And it varies depending upon the size of the estate and how likely it is that there's going to be some lingering issue. But we recommend they keep that small sum, and then 6 months, a year. And I've had sometimes they've gone more than a year, depending on the nature of the liability that we're concerned about. But when the liability period, we're comfortable that it's ended, then they can close out everything and make that final distribution. So some kind of interesting things. What about if we want to disinherit somebody in our will or a trust? Should we just give him a dollar? We see that a lot. I don't want Junior, my spendthrift deadbeat son, to get anything, so I'm going to leave him a dollar. Is that a good idea or a bad
Yeah, typically we would not, if we're going to disinherit somebody, then we will just include that specifically in the documents that we're going to omit them from the estate, or you don't even have to give a reason. But as long as we're specifically saying we don't want them in, we don't need to give them any amount to take care of that issue.
Yeah, and the reason for that, well, two things. You have to mention the son. I've had people say, I don't even want to acknowledge that he's my child. Don't even name him in the will. And we can't do that. We have to name him. We have to say, no, deadbeat, Junior deadbeat is your son. And then you have to say, and I intentionally leave him nothing. If you don't say that, Junior has the right to come back and challenge the will and say, well, Daddy really meant to leave me something and he just forgot. And sadly, that argument wins the day. So it's important that you don't be silent. And the reason why we don't leave them a dollar is if they get a dollar, they're a beneficiary and they have rights. Now they get notices, they have to sign off on the accounting, they can consent or object to things that the personal representative does. So we don't want them to have any of those rights if they're going to be disinherited. So another question that comes up, can I put in my will a clause that prohibits any contest, that says you can't contest my will, and if you do, you're disinherited? And the short answer is you can put that in, but it means absolutely nothing. It will be ignored by the courts. And here's the reason. First of all, there's a statute that says so in Arizona, but the public policy behind the statute is we can't enforce a will until we have proven that the will is valid. So we can't have a will that has not been proven to be valid enforced to prevent a dispute over its validity. So with a will, you cannot have that in there. However, a trust is not a will. A trust is a contract. And consequently, it's governed by different rules. And in a trust, you can say, you get this benefit from this trust upon the condition that you don't. And then we can have our list of stuff. You're not addicted to drugs. You don't bring a lawsuit against your sister. You stay out of jail. Whatever you want those things to be, you can have your little list of conditions in the trust. I want to point out that this creditor period that you see there in stage 2 functions similar to a bankruptcy. One of the things, by the way, America invented this with its Constitution, the first written Constitution in the world. You cannot inherit debt. Debt dies with the person who owed the money. And that's built into the Constitution, as is bankruptcy. But that debt needs to be administered in some fashion. So in probate, this notice to creditors that goes out, and the creditor claim period, and whether the claims are allowed or denied or compromised, that it functions like a bankruptcy, and those debts are wiped out. So if children are concerned, hey, mom and dad just owed everybody money and we're going to inherit all this debt and have to pay it back, you can't inherit debt. The debt gets wiped out. And if you do have somebody that passes away with a lot of debt and a lot of property, that debt can be managed in the probate, and often we can be very efficient in resolving debt and preserving assets. So the probate can actually be a function that ends up protecting assets from some creditor claims. And a final thing I guess I want to add is, if there's real estate or business interests in more than one state, you can end up with a probate in more than one state. I think the most I've ever had on a single case, we had a probate once, I believe it was 7 different states. The decedent had property all over the place. So all those probate costs times 7. It was very long and expensive and aggravating. So as you're talking to your clients, if they own real estate in more than one state, that's one more factor. So we're about to enter thing 5. Remember, thing 1 is probate and transfers of assets on death matter to you as a professional. They matter to your clients. They're going to help you serve your clients better and get clients better. You need to understand what probate is, that it is a form of litigation. It's in the courts. That probate can be avoided by causing assets to be subject to a contract, and the kind of deed or trust or business entity you use affect that. If probate's not avoidable, we got to follow the rules, and we've talked through some of that. So now thing 5 that we're down to is the so what question. We've spent the last almost 90 minutes together. What difference does it make? And I want to make you aware of some tools. One is that screen share we've given you that you can still see. I think we're still sharing that. The 3 stages of probate. That's something we will give you if you want that. You can have that. Another item that we will give you for free is a very comprehensive after death checklist. What do you do when somebody dies? And we have had this run through many attorneys, through funeral homes, through real estate people. Lots of people have looked at this list and contributed to it. By the way, when we give you the free one, if you find something we've left out, I dare you. Find something that we left out and lunch is on me. I will buy you lunch. But that's a device you can use so that you understand it, but also so your clients can understand it. And one of the things that happens as your client goes through this checklist, your services are going to be required to complete it. So it's a great way for you not only to serve your client and help you with your clients, but it helps you build your business. So the so what question, I'm going to encourage you to review this again. Listen to this again. We're going to post it online. I'm going to encourage you to go to our websites. We have more than one. You can find us at probatelawgroup.com and at durfeelawgroup.com. We have a lot of articles and videos there and a growing number. We keep posting to that a lot every day almost. We encourage you to share that after death checklist or this probate checklist with your clients. We encourage you to let's talk about how if you have a client and you've identified that they need something, they need help with a probate, they need help avoiding a probate, they have a trust that's not funded. One of the things that we've talked about here today is not quite right and they need help. Let me suggest to you how to handle that. And this is true whether you're bringing them to us or whether you're bringing them to someone else. Even if you're taking them to another attorney, this is what I encourage you to do. So, option 1, plan A is, if they will, say, while I'm here with you, Mr. and Mrs. Client, let's call the lawyer and schedule a conference. The conference will be free. Call us right there while you're with the client, get the front office, our phone numbers on our websites, and schedule it so that you know the scheduling happened. Option number 2, if they're uncomfortable with that, get their permission to give their contact information to our front office. So say, would it be all right with you if I had the lawyer's office call you and schedule a convenient time to go over these issues? And if you do that, that works. If you just give them the phone number, they're not going to call. They won't call. They'll do something else. And again, I encourage you to do that even if you're sending them to someone other than us. Send them to someone that will be good and take good care of them. And let me kind of comment on that. There are a lot of really, really good lawyers, many that I have high respect for, and they do an excellent job and will take good care of your clients. And I encourage you and have no problem with you using them. It's my belief that there should be a good fit between the client and the lawyer. And some clients will work well with us and others won't. And we're okay. We want to work with the clients that will work well with us, and we're happy with the ones that will work better with someone else going somewhere else. Another thing I'm going to invite you to do, we will shoot out an email. We invite you, if you found this seminar helpful, if you find our after death checklist helpful, if you find what we do helpful, to give us a positive review. And we'll send you a link. And when you do that, if you do give us a review, recite your credentials. Tell who you are. I am a real estate professional, or I'm a professional that does la-di-da. This is what I do. And this is why I had a positive experience, and this is why you recommend. And if you let us know, we are happy to reciprocate. If you are gathering reviews, we're happy to say we give a positive review back at you. I guess the final two things is, if you have not done your own planning to avoid probate or to fund your trust or to update your documents if they're more than 5 years old, get on it. Do it now. You can't possibly give your clients good counsel if you have not followed your own advice. So again, whether you come and work with us or go work with somebody else, go take care of this. And the last thing I'm going to say in our wrap up here is, as co-professionals, we are a resource that you can draw upon. You can call us, you can email us. If you have a question, if you have a concern, we're not going to bill you for that. Send us the question, send us the concern, let us brainstorm with you to talk through, okay, a client situation involving whatever. If we can help, we'll say we can help. If we can't help, we'll say we can't help. And I kind of along that line, so that you know, we do offer initial consultations that are free. Pretty close to half the time, we come away from that conference and either we've done what we can do and we can't do anymore, but the client does not engage us and does not end up paying us. And we're happy to give away those free meetings, because the other half of the time they do need us, and we do end up making a living and pay the rent and the overhead. Today, those meetings can happen like we're doing just now on Zoom or by phone. But you as a professional can draw upon us as a resource if there's questions and issues in any of these areas. So with that,
Looks like we have some more.
do we have some more questions?
Chat
Oh,
questions,
awesome.
yeah.
Oh, lots of chats. Anybody that wants a copy of that document, email us. So if you have to make a change to a deed, so if you have an existing deed and it's not the way it needs to be and you need to change it, yes, it does need to be changed. That's something we can assist with. Yeah, trust lawyers use quitclaim deeds all the time. I'm just going to be crude and blunt here. Only the dumb ones. Only the ones that are not the sharpest stick in the pack. That's really a bad practice that betrays a significant lack of understanding. And that is something, by the way, I have said to lawyers to their face in continuing legal education. I'll say it to their face just like this. Using a quitclaim deed hurts your client. Don't do it. Let's see. All of you asking for a copy of the document, just email us. We'll send that to you. We hope you've liked it. What if the spouse has passed away and there's medical bills? Yeah, that's one of the things. Medical bills are one of the things that have to be addressed in a probate procedure. It has been great. We've loved being with you. I have, let's see. Oh,
It's just, where do we email you at?
Oh, email us at info, I-N-F-O, at probatelawgroup.com. Answer that. Michael's going to type that in for us instead of me saying it. Info at probatelawgroup.com. You can also email either one of us with our first name, Mike at Probate Law Group or Rick at Probate Law Group. Info goes to our administrative help, and they can do that. You can also reach us the same way at durfeelawgroup.com. And let me kind of tell you why we have those two names. Probate Law Group focuses on probate and estate administration. Durfee Law Group focuses on mostly estate planning, and in particular, high-end complex estate planning. But the two work hand in glove, and we work together. So I'm going to say thank you to all of you. Yay, you were awesome. Thank you. And if you've enjoyed this, we have a great time. This is a lot of fun. So we'll do this again. And absent any other questions, I'm going to sign off, and we'll have another day. Thanks. Goodbye.
Thanks, guys.